Okay, this meeting of the joint meeting of the Planning Commission and the Town Board of Estes Park is in session. A couple brief comments. I'll have to shoot out immediately after this meeting, so I'll dash out right when we finish. But my sense, and we'll let the experts give a summary of our last session and the progress that we've made. We're still seeking definitions. You know, change in conditions has led to a lot of debate. Our last session, we talked about that a lot as far as rezoning and planned developments, and trying to get to a definition for the new development code or before the new development code as to what that means, something that we can all agree on. That's my general sense, is we're really looking for definitions. And we talked about it a lot last time, and you can take over.
Hi everyone, great to see you all this morning. Just a reminder, my name's Susan Stewart. I'm a volunteer with the Restorative Justice Program here, and I live in Allens Park, so I'm a little bit neutral territory for you all. Facilitating today with Melissa Westover, currently still part of the Restorative Justice in transition, let's put it that way. Yeah. So
one other housekeeping item, sorry.
Oh yes, please, go ahead.
Nathan reminded me to tell you, these mics are always hot. They are not turn on, turn off like we have on our normal board meetings. So anything you say, breathe or whisper is going to get picked up and sent to the public for everybody in the world to see. Okay, there you go.
Great. So we have basically 3 agenda items today, and it will be interesting to see how you utilize the 2 hours that you have for this meeting. You have the same 3 topics as your last study session. The first one is about the rezoning criteria, and I'll give you a brief recap on that. The second one is about the definitions and some further things that you requested in the last meeting for housing related in the code, affordable, attainable workforce. And then the third one is about the next meeting. My suggestion is we try to limit the 2 discussion pieces, rezoning criteria and definitions for housing, to about 45 minutes, because in my experience with you all last time, when I moved you towards your next topic or towards finishing up, then your discussion got really great, right? So let's shoot for 45 minutes for each of those and see where we go. I want to give you carte blanche to say, let's go faster, let's go slower. We need more time on this topic. Don't move us along, please. Step up and take that facilitated role for the group. Okay, so let's move right into the rezoning. And just a quick recap, I did go back and listen to the previous meeting, and just want to ask everyone also to speak up, because I listened to the recording, and because it's been 4 months since we had that meeting, and so it was hard to hear on the recording. So I would request, when you speak up so that it's clear on the recording, even just for me. Thank you. So you spoke about at the last meeting the issue of the criteria being vague right now, or not having a common understanding of how to apply them, and you talked about whether or not to develop a common understanding of the existing criteria, 3 criteria, or to develop new criteria as an amendment before the code rewrite is finished. So that you still need to, will need to move forward. You discussed, there were several suggestions given, such as get rid of changes in conditions, feature the comprehensive plan. You also talked about making changes in conditions have a boundary of just whatever the neighborhood is, or to remove changes in condition. You all said that the third criteria about infrastructure is a good one and probably should be kept. I just don't want you to have to repeat the same things that you said 4 months ago. I suggest that the easiest way to take a complex question like this and discuss it is saying what, so what does it mean? What's going on? So what does it mean to us? And then now what? What are our next steps? And so around the rezoning criteria in the last meeting, you talked about the what. These are the 3 rezoning criteria. This is what's going on in our challenges with them. And you talked about the so what, which were some of the suggestions that people gave. And so then as part of the so what, you said, well, we need more ideas, more information. And so you charged as a now what, well, as part of the so what, you asked the community development director, Steve Kerchia, I never say your name right, I'm sorry. Karecha, sorry about that, to provide for you a menu of options that you could discuss around these rezoning criteria. Okay? And so the process I suggest for you on this segment is we'll start with the director's presentation, and I believe he also, or Attorney Kramer probably also has some thoughts related to that. And I'd ask maybe that you note down your questions rather than interrupting him during his presentation. So then we'll have a Q&A after the presentation and then move into discussion. Does that sound okay with everybody? Presentation, Q&A, discussion. Okay? All right, let's move forward.
Good morning, Mayor, Trustees, Chair, Commissioners. I hope the packet was helpful, so I'll keep my remarks brief. We did look at the rezoning criteria for several entities within the state. Looked at that, what did they require, how did they use it, put that in a matrix so you could kind of see that menu. That was the charge I think I took from our last meeting. Let's provide all this material so we can kind of see it comprehensively. So in looking at that, again, keeping my remarks brief, it looks like consistency with your comp plan was a major criteria. So was compatibility with the surrounding area. That was another major issue. Community benefit was one we also saw a lot come up. Did this rezoning result in a community benefit? The main one we looked at or discussed, the change of condition criterion, that seemed more of an optional or secondary. And again, I hope the materials kind of show how other entities use that criterion in their evaluation. Another one, change or mistake. That was another one kind of teamed up a lot with change of conditions. Basically, if it wasn't consistent with your comp plan, was there a change of conditions or an error that supported this rezoning? So that's kind of what we were seeing from some of the information we gathered. Staff is prepared to take direction today or future direction. We're prepared to move forward with a code amendment if that is what the trustees and the commission so direct us. And that being a standalone code amendment that we can work in tandem with the overall development code update. So with that, I would prefer to listen to more discussion than myself present, but I know Attorney Kramer also had some thoughts to share.
Yeah, just to follow up on that, thanks Steve. Good morning everyone. So my memory of the last study session, the joint study session, was that it was pretty wide ranging and it opened up with a conversation about the definition of change of conditions. And I made the remark that that might be a little bit of a red herring. It's meant to be a broad criterion, and the challenge that I think both boards have been facing is that the structure of the criteria themselves leads to a lot of weight being put on that one criterion, and it doesn't have to be that way. So what Steve has provided for you all at, I believe, your request from the last meeting is a number of examples of how other jurisdictions do it. It's not necessary that there only be 3 criteria and that one necessary criterion is the change of conditions. So my suggestion to you all would be not to try, we can do it. We can try to pinpoint an exact definition of change of conditions. I would suggest that that would be a long and winding road and that it might not lead to any particular destination. And instead, what might be more fruitful is general direction to the community development department to draft up something based in some way on the examples that Steve has brought to you all, and bring it like we would for any other code amendment to the Planning Commission for recommendation and then to the town board for consideration. You can be as specific or as general in that direction as you like, but only having 45 minutes, I don't think we're going to get to the precise new set of criteria that you all might want to arrive at this meeting. So as you see from the examples, there are many permutations. You can have and or over here, or you could have and or over here. There's not necessarily one best way to do it. Any recommendations that you have for us, of course, we will take and we will try to run with, or we can go in an entirely different direction. But that is my recollection of the path that I thought that we were on moving toward this meeting, which is why Steve put all those examples together.
So let's start with the Q&A. And just to make sure that the what is clear, what are your questions about the report? And I draw your attention to the report and to the criteria matrix that Steve prepared. What are the questions that you have for the director regarding this report? Anything you want to clarify?
I would, I guess, like to clarify. A couple of the public comments talked about, again, getting back to change in condition, that they specifically say physical change and within 500 feet based on our code. Is that your impression?
No.
Thank you.
The criterion is broad.
Yes.
It does not say that. That would not be my advice.
Okay, thank you.
Other questions for clarification about this report?
Have there been court definitions of change in conditions? Have there been rulings that provide guidelines?
Mayor, I would say that there is a large body of case law on the subject, but I'm not aware of any court saying here is the definitive definition of change of conditions and this is what everyone must follow. It's an interpretation of, at this point, individual development codes and whether those development codes have been met.
Okay, yes.
Well, looking at the matrix and even before, I like the idea of changing it from a requirement to a consideration in the list of things, and not a firm hard. Because if it's a firm hard one, then I think the next logical step would be then we'd have to define it. And like you mentioned that some people thought 500 feet. Well, then somebody who lives 550 feet away is going to be upset. But I think we're going down a quagmire we can't get out of if we try and do that. So that's probably why the rest will do that, just make it a consideration for rezoning, but not a requirement. So I like going that direction. Maybe not throw it out completely, but not make it a hard and fast rule.
Okay, so let's go ahead and open for discussion, and go ahead.
So I think change of conditions is just asking for a problem. The term itself, just like change of circumstance, which the county uses, And if it's a consideration, that helps. But I liked some of the things that came up from this thing. The fact, one consideration being that there's a public benefit to the change of rezoning. I think that's a really important one. And I do think fitting in with the neighborhood remains important, which is kind of, I think, that's not a change of condition thing, but it's sort of a criteria that people expect of any rezoning, that it may change things for sure, but it doesn't necessarily conflict badly with the neighborhood area. So those two, to me, make a lot of sense to be considerations.
I agree. I think the things I picked out of the documents that you provided from different cities, when there was a demonstrated community need or a community benefit that might be attained from this, that maybe outweighed any negative that might be perceived, was something that I really thought was important.
When you look at the this matrix was really helpful to me. I appreciate that. And in ranking those, it appears that, and you have to kind of trust the collective intelligence of all of these cities and organizations that have, through time in this process, figured out what's good for their community. So I put a lot of confidence in maybe this type of a document, but change of conditions being the number one most common thing here, consistent with a comprehensive plan and community benefit. And those being the top three, compatibility with surrounding areas is less than 50% of the documents that you surveyed. So that's telling to me that perhaps there was conflict, perhaps there was confusion, perhaps there was a perceived benefit of changing the future for the benefit of the community, and that has to be weighed heavily in the conversation. So thank you for putting this together, but this gives me a different feeling of what maybe a direction we should be focusing on, and that's not what's within a certain number of feet of a specific parcel. Because I think we do get into a jam when we look at how can we zone this specific parcel. Just seems to open a door that it's not necessary. Decisions, definitions, and complications.
I do like the idea of a technical correction too for an error. Probably should have that anyway. I know there have been a couple of times that I've been involved where we had the map was wrong and it was just a mistake. And that's more of an administrative thing than anything else. I'm surprised we don't have that in there.
Can I just ask Eigel to clarify what you're saying about, because I think I'm getting the wrong thought process in my head what you're saying about.
I do that a lot.
Yeah, I know. I just get it. No, it's true.
It's active listening, right? Thank you.
I am actively listening, but I'm like, I kind of lost you there at the
Yeah.
end. So are you saying that in line with the current neighborhood or current standards is lower in the list?
It's lower in the list when you survey other organizations and municipalities, and for me, I don't want to drive through a neighborhood and see something that is high rises with estate zoning.
If you stop there, I
That's
agree with
one,
you.
yeah, that's one
We all
example.
can agree with that.
And I think that there's so much here that's subjective, that until we nail this down, it's going to be hard to say this is where we stand. So I am becoming less, throw a couple of cards on the table here, Marie, and I'm becoming less tolerant of big changes to our community to accommodate the needs of someone who comes in and sees a solution before they understand the problem.
Oh, I'm right there with you.
So I'm not.
But I guess I
I'm
thought
not about
you were
putting a
saying
high
the
rise in
opposite, and I
middle
was
of-
trying to figure out
I'm
what you were
I'm
saying.
not. No, I don't
Okay.
believe we should put high rises in the middle of the state zone.
Okay, that's.
all.
And I thought that was what you thought, but I wasn't sure when you
No,
said it.
no. I think it's interesting to see that all of these entities, it's a lower priority to be similar to the neighboring use.
Right, and I do find it interesting, but I wonder if it's more because we're looking at Loveland or whatever. They're larger communities, and they don't have that small town feel. which it does make a difference in the head, in the brain, you know, or maybe it's just assumed that if you have a golfing community, you're not going to put a high rise in the middle of it. You know, maybe those are. But I agree with you now. I just
High rise
I
for
was
us
hearing
being
something
3
different.
stories or 4 stories.
Yeah, no, yeah,
not
exactly.
the 12 stories.
But I was just trying to, because I just thought you were saying something different than what you said. That's all.
Yeah, try not to use specific example. I'm going to try not to use specific examples today, but
I think that's fine.
interesting how other communities take. So I'm taking and leaving some things in my comments.
Okay, anyone else?
I would just add to that I think what's compelling about the matrix, which was really helpful to look at it from this like a visual learner kind of perspective, is the compatibility with surrounding areas are most like they're mountain communities. It's Steamboat, it's Crested Butte, it's us, you know, and then you look at Lovell, Longmont. It's just to your point there, Marie, that it's a little bit different. So I mean Fort Collins, but Fort Collins feels like a little mini mountain community that they've tried to hold on to that. So just an added point. Thank you, Steve.
I was just going to follow up with some of the comments. We did go for a wide variety of communities, and we picked them without knowing anything about their criteria. So there was no preconceived notion. We just picked towns. We wanted a good ring around Estes Park. The other thing I would add is I've been a part of large communities, over 100,000, smaller communities, mid-size, similar criteria. And it's interesting that no matter the size, the problems, the questions are still the same. So Estes Park is not necessarily different from Fort Collins or Longmont or Breckenridge. We have the same issues coming up. So I just wanted to make that observation that I've seen.
That's a great point. Any other?
I just wanted to put one point is it's a conflict between property owner rights, community rights, and the issue of how strict it is compared to how flexible it is. And I think it's, you know, and that's a judgment that I think each governing body is going to apply differently. That I don't think you can say it's going to be stricter, it's going to be loose. And so I think by necessity there's going to be some sort of discretion involved by the governing body no matter what. And I think we need to be aware of that. And that's part of the reason I just think that when you think about private property rights, which is not really our purview as a town, but the future of the community is, and that's why I think benefit, public benefit is a really, really important criteria for us. It's less of a criteria for the actual developer, but it's really I think the gating thing for us. And then we will apply discretion in what we believe is a public benefit. So.
I just have one other question for anybody, really. You know, we have if we look at the matrix and we say that our change condition is we're the only one that says yes, right, of the group. If the say we had everything across the board yes and not that, why wouldn't that be the same thing? You see what I'm saying? I mean, if it provides a community benefit, well, that's a change of condition because the changes of the community benefits change. You know, what we need is a community benefit. If environmental preservation, well, if we have a water shortage or something like that, that's still a change of condition. So, I mean, if we took out change of condition just completely, but all these other things were important because environmental preservation is important to everybody at this table, I would guess. I mean, we don't have it in there. So if we had a yes there and provides community benefit, I think that's a lot what we're talking about changing conditions. Every time we talk about a change of conditions, that's what we're really talking about. It hasn't been change of topographical, like we had an earthquake, whatever. It's always been community benefit. Corrects technical error, I actually consider that a no-brainer. It should be there anyway. So if we had yes across the board on those, and we took out change of condition, aren't we doing what we want, like what we were supposed to be doing anyway? That was my question.
Well, change of conditions is something that is ahead of the zoning change. And changing the zoning that results in a community So everything else seems to be as a result of zoning changes, and that's the only thing that would necessitate a zoning change or a technical issue.
I guess when I say provides community benefit, I'm actually looking at that as being that is a change of condition. I mean, that's how I've always voted as change of condition, not, well, I mean, maybe we have more people in town, whatever. But in general, my change of condition in my thought process has always been that we needed more housing, which is a community benefit. That's what I was looking at. Maybe we word it differently, but all these things that the only reason I think to change a zoning is a change in conditions, but it's usually one of these things to me.
Well, why is it not required in all of those other municipalities?
And I don't know. It's a good question. Although when you look at, say, Loveland, everything is marked. You know what I'm saying? Except for the surrounding areas, which I don't really totally get that. But everything's marked yes. So that's their change of conditions. As far as I would look at it, like if I was looking at these, I would be like, okay, if we need more housing, that we had to provide a community benefit. So that is a change of condition. If and then we say, actually here they do say change condition, circumstance, character. Everybody says yes to that. It's just not required, but it's consideration, which we talked about, which I think is good. But I just don't see anything that's in this list that probably wouldn't come to talk about. I just wouldn't. I mean, I think environmental preservation is really important, and we don't have it marked there. And there may be something, I'm trying to think future-wise, that we have to preserve the environment, and that shouldn't be changed or should be changed because of it. And I can't think of an example, so I have to bring up an example. But I guess I just look at it as being, as we consider all of these things, to me, it's not required, but it's all in consideration. Like, we have to consider all these things before we make a change.
I agree, and I think we've been saying that a lot here in recent history, that any development that we do, we should be weighing the community benefit, the environmental preservation, all of those components come into the consideration. We and future boards have to weigh that, but as long as we leave that as a required condition of approval, we've got a hurdle we're going to run into over and over again.
I agree. So if we took out the requirement, but we consider all of these things, I just think that's a good way to look at it.
So is that a decision that we can make, or is that keeps coming up? If it's a requirement, it opens up all these doors, it creates legal. So we keep talking about defining that. Is it someone needs to raise their hand and say, well, let's not make this a requirement? Is that the direction that would answer these questions?
Code amendment.
Yeah. So
That is a way to do it, Trustee Eigel. So just like a technical error, fixing a technical error, that's not a requirement in order for a rezoning to be approved. We could put that in there as a reason for a zoning to be approved, and change of conditions could similarly be a reason, but not a necessary reason.
Can I just time out and ask everybody to please speak up? I've noticed that some people observing are leaning forward trying to hear you all. So, not to interfere, but yeah.
What this does also,
sorry.
is that the town changes over time, correct? The community changes over time. The board changes. The planning commission changes. All these changes happen, right? That should go along with what the town wants. So if we're requiring something versus we're considering things, I think it helps with that change. So if it's a new board 10 years from now, and they want to consider these things differently than, say, I consider it, which would be foolish, but you know that. But if they do, then it's still going along with what the town wants at the time. And that's why I would say take the requirement out, but all these factors should be considered. Because I do think they're considered anyway. So, okay.
Well, I think the environmental preservation is an interesting one because that might be a criteria to avoid a change in condition, not because of a change in condition. Which might be a reason in certain cases to protect a piece of property is to avoid change in that property. But I do think one thing we can't minimize is we do have a responsibility to private property rights.
Yes.
And there is a balance there, and we have to look at that. That's part of what we pledge an oath to the Constitution, and those are some fundamental values. And community needs can't bulldozer over private property rights. So that has to be a consideration in all this as well.
I think. Oh, sorry. I was
go
just
ahead.
going to add on to that. I think that that's spot on, and I think ties into what Bill was saying too. And no matter what, Marie's suggestion, I'm really, it makes a lot of sense to me. But no matter what, some of these are going to be kind of nebulous in terms of interpretation anyway, which is our job as board members to represent different segments of the community. What I think might provide community benefit might not be the same as what Mark thinks provides community benefit, right? So I think if we're trying to like evade the nebulous, of these kind of criteria, then I think we have to kind of get over that, which I don't think anyone's really suggesting by any means. Change of condition in particular has caused a trip up, and I think that's why Marie's suggestion is really compelling. But I think no matter what, we're still going to have those moments of like, okay, environmental preservation, to what level is someone's personal threshold on that in terms of the representation on the commission or on the board?
Right. And I think if anything, the personal, to me, which is interesting coming from me, is probably far on the liberal side of things, but the first criteria is the constitutional rights and private property rights, and then we have to have compelling reasons to limit someone's
Right.
personal property rights, and there are good reasons and safety reasons,
Health and safety.
and even all these other things we have there. But that has to be where we start. Is someone has a right to do something on their property, and then we have to have a compelling reason to limit that in some way or manner.
So we include in there. I mean, I actually don't think we have to have it in writing, but if we have to, we have to have it in writing. Is one of the things we look at is the consideration of property rights.
Well, sure.
I mean, I think it's unsaid, but obviously not all the time.
Yeah,
So
for real.
But so is so are all of these other areas. They should be unsaid common sense.
correct. So
But I agree with you wholeheartedly, and I appreciate that Frank raised it.
Yes.
Property rights do matter, and
They do
property
matter.
rights are,
and it's
are high priority for me.
and it's then we have the question of this: is it the property rights or is it the neighbor's
Right,
property rights?
Right.
And that's a big league. Look at Bill. Bill's jumping at the thing.
Yeah.
But and I do think that's a big discussion. Because you should be able to enjoy your property, but does that invade my own property rights?
So Mayor Pro Tem and others on this topic, my thought is on that the development code itself, and right now we're talking about rezoning criteria, that is the community's or the board's answer to how are we going to attempt to balance private property rights with community rights. So that should be a purpose statement for our whole development code if it's not already, and I think it
Yeah.
probably is.
Good point.
So embedded in each of these is an attempt at that balance.
Keep that in front of us the whole time.
Kind of a mission statement. for
Yeah.
it.
So,
that's
so
good.
I'm watching the time, and maybe I want to try to summarize a little bit to see if you could take a next step forward. It has been mentioned that there might be a number of considerations as opposed to criteria for rezoning, and they include the community need or benefit in line with the neighborhood, the technical correction for an error. Let's see here. All of the
Yeah,
other
all of
criteria
those.
in the matrix
And property rights.
and property rights. So those are all put forward as conditions. So in that case, what would the criterion actually be?
Well, what I'm hearing from the conversation, and stop me if I'm wrong, I'm not hearing anyone saying that any of these criteria that Steve has listed on the matrix is a problem, we should absolutely keep it out. I'm hearing that a broad list of criteria structured appropriately so that some are ors and some are ands is what we're aiming for. And we can draw something like that up unless you want to get more specific about what exactly you'd like to see.
No,
I think that goes back to we talked earlier about the discretion.
Yeah.
These are so different. Has to be the discretion of the planning commissioners, interpreting the community's values and how this goes, and property rights, and then ultimately the town board.
Yeah, ensuring when these topics come up before the board and before the planning commission, that there is a list of these are the things you should be weighing, but not a formula that says you got to add 2 + 3 and subtract 5 and get the answer. You're weighing it. You're not using a formula to compute whether or not you're going to pass that.
That's right.
And that's what we're here for.
And that's why we have some quantitative criteria that are already built into the development code.
Yeah.
And these are very qualitative,
Very
and that's why we have so many of you weighing in on each of these questions. That's why we have a planning commission and 7 board members.
So how about you already have a criteria related to the comprehensive plan? How does that fit? Because nobody's really talking about that here. How does it fit? So one option is just to make all of these on the matrix criteria that are not worded as must-haves, but in some way that make it more open to the decision of the boards. I'm not sure that that's going to lead you to resolve some of your anxieties that you have about these decision-making processes. But how about the comprehensive plan? That's your number 2 criteria right now. Where does that fit?
Well, I think having having them be just criteria that we look at, none that have to be, you have to have exactly. It has to be this because it's too broad. Just like change of conditions, it's too broad. So if you have all these criterias that you're looking at and that you examine, and then you can come to a conclusion without having it must be A, B, or C. I think that's just too difficult, and I think the plan also, the development plan needs to be in there as well, looking at what's ahead, what we're gonna, where we want to get to. Those all need to be in our thought process of what we want the vision. Does it meet the vision? Does it, do we move forward in that, or does it even look like it at all? I don't know if I'm if I'm explaining myself all right, but I think having a consideration is much easier and broader than a requirement in any of those that we've discussed.
I have one other thought on that, though. Sorry, if I'm jumping on somebody. Sorry. Frank brought up the constitutional about having some kind of change to have happened. So what if the broader statement is that has been a change? It's required to have a change of conditions. Absolutely. But under there, these are considerations that we consider change of conditions. A comprehensive plan may change. We may have a different comprehensive plan in 5 years. Who knows? So if that's the case, that's a change of condition. If the environmental preservation, we find out that we have a lack of water, that's a change of condition. Provides community benefit. We all know that community benefits change. Whether we have too much housing, Scott's going to fall over his chair if I say that. We don't have enough housing, that's still a change of condition. And so all these things we should be looking at whether they're a change of condition, I think. And that covers the constitutionality of it, because I do think there has to be some kind of change. If I buy a house and it's zoned whatever, if we're just kind of willy-nilly changing it, I don't think that's really fair. And I don't think we do that. I think we actually say, okay, there has to be some requirement why we're doing that. Is it a change of the community benefits that we need, or is it technical error? Is it compatible with surrounding areas? That's probably not a big change by any means, but maybe across the street there are high rises, and that is kind of a change of condition. But I do think there has to be some kind of change. The question is defining it, and maybe we define it by all these things in the matrix.
I think so, Susan. I'm glad you brought it up, because I think for me, I'm like, it was just implied that we're thinking that the comp plan is kind of like the arena within what we're working.
Yes.
Like that's the
Nobody's said it
fence,
before.
right? No, but I'm glad that you called it out, because that's in my brain. That's where, that's the fence that we've built around this entire thing, and we're just operating within that fence. And I think that's an interesting point, Marie, that we have considered change in condition as like another one of these items, when in reality it's kind of the overarching theme, right? And in particular, I know we've talked about this a lot, that there's conversation about does the comp plan constitute a change in condition, and some people don't believe that it does. To me, I'm like, that's the most compelling because it's the way that the community has come forward to say, this is now what we vision for you know, what we want in the valley. And so I think I'm glad you brought it up, and I think that that needs to be a really key component, is like us working within that framework, as Cindy said. Like, we're operating inside the arena. Like, we're not going out, we're inside the arena of the comp plan and do each of those things, which I think are pretty well defined in the comp plan, actually. Yeah, does it align with those, or can it be justified by those?
I think it has to be there because otherwise it almost it minimizes the importance of the comp plan.
Right.
It takes it away. This is how the comp plan gets
Implemented.
implemented.
Right.
Exactly. And unless there's that connection, if the two things, if our development codes and our rezoning criteria are completely separated, not tied to the comp plan, it diminishes the impact of the comp plan. So I think it has to be there.
And I think that's the key. Sorry, Cindy, I was just gonna say, I think that's the key piece is we're talking about how can we make decisions that aren't within such a rigid set of framework, because that's not like a reality for us to be able, because there's so many different elements of how our community operates that a rigid set of framework or set of criteria, that framework doesn't work. But we're not looking to say it's a free-for-all, we can make any decision we want as a board no matter what. We're still operating within the comp plan.
So,
Yeah, that's
then
like
the
our
title.
Bible, or
Exactly,
you know,
yeah,
I mean,
yeah.
it's a valuable document that we need to make sure that we're always referring back to or looking at.
Are we shifting then from
For
a guiding
consideration.
document to a controlling document?
I don't think anyone's
No,
suggesting
not a
that.
control.
Because a guide,
Guidelines.
comp plan is a guide,
Yeah.
Yeah.
right?
So,
But not a fence.
Marie, your comments are exactly why I think we should drop change of conditions altogether, because all these considerations are what's justifying a decision. And it's hard to say, well, there's just a change of conditions. That's so vague that it doesn't justify it the way it does all these other criteria we're looking at. And I think it just confuses the matter. And I do agree the comp plan is a critically important part of this. My understanding is we actually adopt the comp plan as a guiding document by the board, and there's been some comments about it's not adopted by the board. Well, it is.
It was.
Yeah, it was adopted by the board, and so
And the planning commission.
Yeah.
right, and it is
Officially.
kind of by adoption has to be a guiding document.
So do I hear from these various comments that, so in my mind, and maybe you think differently, a criteria is it must have this. Whereas
not
a
necessarily.
consideration, I mean, I don't know what the actual definition
Right.
of criteria is, but in my understanding of the word criteria, it has to have this. So right now you have 3 criteria. It has to have all 3, right?
Well, the general consensus around the table, although Bill is taking it to a more extreme level, the general consensus of several has been that the change of conditions ceases to be required. And like the other criteria, including the ones we don't have even marked here yet, environmental, et cetera, community benefit, that all of those are within that field of consideration. So maybe the word criteria is throwing us off if that makes it sound like a requirement. They are considerations. Now, Bill wants to eliminate the change of conditions entirely.
Well, actually, I
Maybe not.
could retain it insofar as, the people that have been objecting to some of these rezonings view it as only a physical change of condition. Well, a physical change of condition could be a reason. So if you have a neighborhood fire that takes out a bunch of properties, as an example, that may be a good reason to rethink what that neighborhood looks like. So I wouldn't, I'm reacting so much to the controversy about change of conditions, probably, and maybe too much. But it's, I can see it might still be relevant in, maybe a change in physical conditions, something like
Well,
that.
it's still it ends up being an overarching. Just like you have the comp plan. Let's put that on top. And then the next thing is, why are we changing the zoning? Why?
Yeah.
Because some condition has changed, and it's one of
Human,
these in
yeah.
consideration. So it's almost like, okay, there is a change in conditions, but underneath there, I'm seeing a poster, underneath there, it is based on these considerations.
Yeah,
Yeah.
let me ask this,
So
kind
it
of,
would say at the top, the criteria is must go along with the comp plan. And under that, this is how we define that or whatever with change of condition, meaning all these other things. Is that what you're saying?
Well, not necessarily has to go. It like so the comp plan guides it. The comp plan is not the development plan. They're two they're two separate things. The development plan is based on the comp plan, but so I don't know if I would word it that way.
As a criteria, though.
Yeah, as a criteria, absolutely. I guess. I do. Not I guess. I'd love to hear from Travis because Travis is over there biting the bit.
Yeah.
And he has such a great way of wording things.
Yeah, I think some of this will be easier when the text of an amendment is there for consideration.
Yes.
Whether it's
Chase
what
my tails.
feels like, does anything feel like it's a have to have, or it's the totality of the considerations that we've laid out today, and do we want to include the change in condition as a piece of the broader overall picture, or do we want to just consider all of these other things that we've discussed today as the change in condition underlying, which is what appears that many of these other communities have done. So I think a lot of this conversation will be facilitated by some actual text language that you all can react to and respond to and say, this is how this reads to me, this should be more prevalent. I think that's what Attorney Kramer was talking about when he was discussing the structure of the code amendment.
so one just minor follow-up on that. Someone could say, well, this property is sold and the owner wants to use it differently. Is that a change of conditions? Now, I don't think that's what's envisioned here.
No.
But it could be interpreted that broadly, and that's my problem with the term.
Well,
right, but
and-
we're considering these things. I'm sorry.
No. I feel that a lot of the issue is people's perception of what that means.
Right.
And if we cannot define it, then it's like what you and Marie, it's like these are all changes of conditions.
Yeah.
So if we can't specifically define it, why use that verbiage? I think we can change the verbiage into something that it can be very clear and understandable, and I think that's our problem. It's not.
And more
And s-
justified.
Yeah.
Because you can specifically say it's this, this, and this.
Well, and to Marie's point, those are all change of conditions. So why are we still wanting to use that term when it can't be defined?
It does get back to the concern that Trustee Lancaster raised early on in this conversation, that it could be anything or nothing. And the discussion we're having today about all of these other pieces that could be considered change in conditions really highlights that, well, there's a little more specificity if you go down this road than if you just try to encapsulate all of that in a single criteria and let a variety of boards across a 20-year period try to interpret what that means to them, what that means to the community at the time. So I do think, and what I've heard from most of the board members and the planning commissioners present, is that the idea of shaping and structuring some criteria for consideration that include a broad range of changing conditions, and if we refer to changing conditions, we do so at a very kind of high-level policy type statement as we're introducing the considerations that are being discussed. I think some of the kind of the wording back and forth will be much, much easier once you have a structure that you can look at instead of trying to talk
Chasing
through
our
it
tail.
yeah,
Yeah.
verbally. So I would suggest that you let staff have a crack at drafting that structure for consideration and further discussion, because it's much easier to move words on the paper or strike through things than it is to create it in your mind, have everybody have the
Especially for
same
this group.
structure created.
So do you feel ready?
I think we're on the right track. I think part of it might be semantics when you're talking about criteria. To me, criteria or circumstances are optional considerations or versus requirement. I think we're all agreeing we don't want any of these to be a requirement. I think one of the that might be helpful is let's look at it from the other side. What would we say we would not want this to be a criteria for rezoning? And when I was on the Fort Collins Zoning Board of Appeals, one of the things we always used was self-imposed hardship. As that is not a criteria for getting a variance.
A variance,
Yeah, it had to be something physical or something. some
What
other
did you
change.
say? What was the-
Self-imposed hardship.
Okay.
So that
Traditional criterion for a variance. Is
right for a variance, but in the same way with rezoning, would this cover it if somebody came in and said, "Well, the change in condition is, I inherited this from my grandfather, and I want to buy a hotel."
Yeah, it shouldn't be a basis.
That's the self-imposed condition,
Yeah.
and I think we want to make sure that we can say no, that doesn't fit our criteria. So, what are the areas that are when we look at this, flip it around and say where are the areas we really think rezoning would be inappropriate, and would any of them cubbyhole into these and get us into trouble?
Good idea.
Are you ready to ask staff to create a draft? Yeah.
Yes.
So, Director,
plan.
do you have questions of clarification for the members here that would help you in that drafting process? Or do you feel fairly clear?
I feel fairly clear. I think the direction was understandable. I think between the direction we received today, the research we've done, our experience, we can bring back some language for consideration, and I think that would be helpful.
Yeah, I'm sure we'll be working together on that. I hadn't considered the idea of putting changing conditions at the top and having other things fall under that. Give us a chance to think through that and see what that might look like. I'm not sure that I've figured out in my head exactly what all the issues with that might be, but we'll work on it. We'll figure it out. And we'll get you a draft.
I think realistically too, we need to realize this is probably going to be better public policy and better community planning. It's not going to make rezonings any easier.
No. That's exactly right. That's
It's
exactly
not.
right.
It's still going to be controversial, and we're going to have people angry, and so it's.
You're right.
I wish we could fix it, and it would all be everybody unicorns and rainbows, but it's not.
But still, this is great
Pixie
work
dust.
for clarifying
exactly.
what you have, and it's very hopeful for next steps. So that should be about rezoning criteria. Just to
I asked for
clarify.
more specifics, but I didn't have the opportunity.
Okay. Are you ready to move to your next topic?
Yes.
Okay, good. Good work. I'm very impressed. One thing I wanted to just remind you, we in the previous meeting, you mentioned that you wanted. Is there something else to bring up? Or?
No.
Good?
Sorry.
Okay. You mentioned that you wanted to keep the community values front and center as you're studying together, discussing together, and so we just included the page from the comprehensive plan. The one side has the vision, and the other side has guiding principles, which last time you talked about these guiding principles actually being agreed upon community values. So we wanted to, since you said in the last meeting you want to have this front and center as you discuss, and remember that we gave you a copy of that in your packet. Okay, so your next topic is about it's titled Definitions, Workforce Attainable Affordable Housing. Let me just recap briefly. In the last meeting, you talked about both the what are our definitions, and the so what do they mean for us? And you asked for more information. It was interesting to me on listening to your meeting that 3 different people asked a key question, I think, that is worth repeating, which is, what are we trying to accomplish with density bonuses, and how are the density bonuses influencing that? So you have your code, which has your town definitions of workforce and attainable. It doesn't have affordable. Right? Yeah, that's correct, right? And then what you asked for was a number of things. A refresher of the current definition of workforce housing in the code, how this definition is being applied, data on demographics for Estes Park, including seasonal workers, and data on the current housing inventory. And you asked Housing Authority Executive Director Moulton to give you a brief presentation on that data so you could continue your discussion. So again, I suggest presentation with no questions, then Q&A, and then discussion. And thinking about that overall question in your mind about what are we incentivizing and how do we or do we not influence that or accomplish that with our code. So I will turn it over.
Thank you very much. Trustees, commissioners, thank you very much for having me this morning. Hopefully you all had an opportunity to at least glance at the presentation. I'm going to go through it very quickly and be as concise as I possibly can so we can open it up to discussion and any questions you have. I want to highlight a few items right off the bat. What you do not see in this presentation is concrete data on seasonal housing needs. Given the season we're in, which is summer, most employers are quite busy at the moment, and I intend, in coordination with the chamber, to gather and have a more robust data gathering effort as we enter into the fall when employers have a little bit more time, because that is one gap in the housing needs assessment was around the seasonal housing. We can take a deeper dive into what that need is. So I wanted to acknowledge that shortcoming in this presentation, but I intend to follow up hopefully before the end of this year and provide a better picture of that seasonal employment and housing related need. So let's jump right in so I can go through this very quickly and then we'll open up the floor. So we talk a lot about affordability. What does that mean? The common definition of affordable housing or affordability simply means that any given household is not spending more than 30% of their gross income toward housing costs. That's it. So something is affordable, everything is affordable to someone. Whether that's $300 a month in rent or $30,000 a month. On slide 2, you have a breakdown of our local Larimer County AMI levels. Those common definitions and buckets of 80, 50, and 30% area median income, and the common definitions that are applied to those, which are low income, very low income, and extremely low income. And I presented the data in a little bit different way than we've presented in the past, with ranges of both hourly wages and annual salary, so you can review that graphic. Attainable housing is not a common term in the housing industry. We do have it defined in our development code currently, and my definition is on the slide deck as I talk about the definition of attainable housing. In the development code, it means housing units are attainable to households earning 150% of Larimer County AMI or below, adjusted for household size. This applies the same for renter and owner-occupied homes. The definition of workforce housing in our development code is at least one resident in the household is employed within the Estes Park School District boundary, full stop. Going on to slide 4, you asked for data on current housing inventory. So there's a lot of numbers on this page. We're highlighting total housing stock that comes from the 2022 Housing Needs Assessment in the Estes Valley area. That is 9,510 units. And I have a breakout of income restricted units in the valley and workforce restricted units in the valley. These comprise both rental and owner or for sale product in both of those categories. I think it's important to highlight in the bottom right that effective in 2013, we did have a bonus density of 150%, which allowed up to 12 units in RM zoning. In the period between 2013 and the enactment of the 200% density bonus, no units were brought to market using that density bonus. the density bonus, once it was increased to 200%, or allowing to go to 16 units per acre, the market brought 188 units to market using that density bonus. Slide 5 is a breakdown of income qualified rents and workforce restricted rents, and then the AMI as charged. What that means is rents are set at an AMI level, whether that's 30 all the way up to 100 or more. But what we locally charge, specifically for primarily EPHA housing options, is less than the top end number that we're allowed to charge. I also want to highlight that Prospector has reacted to the market and has lowered their rents in the last 40 days to roughly match EPHA's workforce restricted rents as a reaction to the market. Slide number 6, workforce qualification income demographics. We have a pretty large data set as EPHA is tasked with doing all of the qualifications for both in any income for our properties or owner occupied income restricted, as well as workforce restricted units throughout the valley. So we have all of the data that is associated with that. So the income and AMI averages that you see on slide 6 are actual data as it's being used and qualified for occupancy. Slide 7, I provided a snapshot of local job openings that were posted just within the last 3 weeks. It is just a snapshot. It's not meant to be all inclusive of all the job openings that were out there. And I provided, I'll explain the chart very briefly because it's confused a few people, so my apologies. Yearly high range at 1,560 hours. That is the equivalent of 30 hours per week. And then full-time is 2,080 because that is a significant impact on our local employees, because not all of them work year-round 40 hours a week. And then we carry that further to the right if there was a 2 wage earning household and they both have the same income potential. That is what you see off to the right. Moving on to slide 8. This is a breakdown of deed restricted housing occupancy, including rental and occupied. So as of early August, you see these stats in front of you. Income qualified were essentially 100% occupied. Workforce deed restricted, there's a few vacancies on the private side. The 2 properties, the 2 largest properties in the valley that are still in their lease up or stabilization period are roughly 50% occupied, 50 to 55% occupied, which is completely normal. We anticipate anywhere from a 12 to 18 month stabilization period, particularly in a market like this, particularly in light of the fact that we added more than 200 units to inventory in less than 7 months. So that is a lot to absorb in that short time period. So the gap in occupancy you see at the moment is normal and expected. If you look at owned units and rental, we have a 15% vacancy rate, and that is a pretty striking number considering the amount that we've added to inventory in a very short time. Slide number 9, active rental listings. This was again a snapshot of active rental listings, not meant to be all inclusive, but I used several sources to compile this and do a breakdown of what is available on the private market based on unit size, their average and median monthly rent, how that equates to AMI, and then of significant importance is of course workforce rental assistance, which is meant to bring the market cost down for those qualified households who need it. So I showed the impact or the potential impact off to the right. Slide 10 shows what does home ownership look like through the lens of the current development code as it defines attainable housing, which is again that 150% area median income or below. So this provides sort of a breakdown of potential housing costs. The bottom line is the median home price for detached at the end of 2024 to show a comparison of what households, what that 150% translates to in terms of affordability, and what impact that definition in the code has, or who would qualify for some level of deed restricted housing using that provision from the code. Slide 11 is a snapshot of what does the real estate market look like now. I've broken it out by detached and attached homes, by bedroom size, average price, number of listings, and I think a significant consideration in the valley is the age of the housing stock. Those are some pretty stark numbers when you consider the age and quality of homes available. My favorite was the one bedroom detached home built in 1907. And then the last slide is as we work to stand up our enhanced trailhead down payment assistance program, where will that fit and how does that compare to the current market? If you recall, we are setting that criteria off the bat at $650,000 or less. These are the homes that are currently on the market that program could support. This was was interesting data to look at from my perspective. I will now open it up to discussion about definitions. Any questions you have for me about data or anything else?
Well, let's start with questions.
Could you just explain deed restriction again for all of us?
Certainly.
Could you see that a little bit
Could
louder?
you explain what deed restriction means?
So in order to use the and I'll put it through the lens of why we're here, or why I believe we're here, which is the definitions used in the development code. So if a developer seeks to use the development code and the bonus density specifically, you can correct me if I say anything wrong, whether that's the attainable portion or the workforce portion, and they use either the density or the height bonus, that comes with a deed restriction that is recorded on the property. The development code has a minimum requirement of 20 years, but it could go all the way up to 99 years. So any housing stock that was created using either one of those provisions has a recorded deed restriction restricting the use and qualifications of the user of that property to fit the definition that they receive the bonus density.
Can I read what I think is a very good general definition?
Yes.
Of deed restricted housing involves stipulations in a property's deed that limit who can purchase and or live in the home, often based on income, employment, and other factors. These restrictions are legally binding and aim to maintain affordability and availability for specific groups in the community.
It is the thing that makes sure that the home is used the way the development code foresees it being used into the future.
Except for race restrictions. Can't have race restrictions.
AI.
And if the development code changes from when the deed restriction was issued, it remains with the original. It doesn't.
It's whatever that deed restriction says.
Okay, thanks.
I have a question. I've seen somewhere that there's an AMI for either Estes Park or the Estes Valley, and yet we use county. What difference would that make?
There's not a local and
There is not a local, I saw something, yeah.
it is all based
It
on
maybe
county.
not an official one, yeah.
It is all based on county level or MSA data. So
Great research, by the way.
Yes,
Appreciate
yeah.
that, really do.
Other questions, clarifications? I have a lot of stuff presented here. Yes, go ahead.
I have another question about prospector on your slide number 6. You're listing prospector attainable and prospector workforce. Could you explain the differences there for me?
Yep, Prospector is a unique property in the valley in that it is restricted in 2 ways, but it actually provides some additional flexibility. So an occupant can qualify to reside at Prospector in 2 ways, either meeting the workforce definition or the attainable definition.
Scott, in slide 7, that's a good representation. I'm really glad to see jobs in there that are not on they're not poster children for this program so far. We talk about, we want police officers and firefighters and we want teachers. Slide 7 says those are the highest paid people in the community. So I think that we've got to really consider dropping those important roles as poster children for this program and saying, we need the shuttle drivers, the Safeway, the front end, we need the YMCA, the ROC, we need the people who are a critical part of this workforce to be the focus and philosophical objective of what we're trying to accomplish here. And every time I hear firefighter or police officer, I think, those are pretty good jobs. And I hear from other people that say, those are pretty good jobs. Why are we creating housing for that group? So this catches my attention. I'm sure this is going to start some conversation. And the other question I have is, one of the slides said the American dream of home ownership, but we limit the equity, we limit who can own the house. What is the American dream of owning a house? So these are a little bit philosophical, but for me, this is the program. And when we talk about being able to afford it, workforce for me, when there was an election that I participated in, was things that people who drive shuttles and work at Outdoor World and things can afford. And it feels like we're adding a definition of workforce that is market rate housing, and we're getting away from the understanding in the early days of what is workforce housing? Well, it's something you can afford if you work here. So it feels like we're changing the definition to meet the needs of the program versus it's how it feels.
Trustee Agel, I'm very glad you bring up that point. Personally, I'll use very strong language here. I despise the use of specific positions to justify or define workforce housing. I think it's inappropriate. I don't like that our industry or proponents for housing tend
It's
to do
emotional.
it. I don't do it. I don't think you have ever heard me mention positions, particularly those bellwether, hospital workers, firefighters, police. You won't hear me say that. It is, housing needs are across a very broad spectrum that not only includes our workforce, it includes our senior, it includes everybody, right? So I'm glad you bring that up.
Thank you.
It is not used by our organization as the bellwether or the mark in the sand that we need to try to hit for workforce housing. We don't use those position-specific ideals in that framework, so I'm glad you bring it up. We could spend hours discussing the philosophy of deed restrictions and the ownership model. Those are things that the EPHA board will be diving into in great detail as we work to bring more ownership opportunities to the community. And it's always about trying to thread the needle on providing the benefits of home ownership, the associated equity gains, and all of that. So we'll be talking a lot about that in the coming months.
Any more questions for Executive Director Walton?
No, kind of. It's kind of a piggyback onto Mark's comment.
Well, we could move into discussion
Oh.
if we don't need to
It was,
clarify anything.
it was
anymore.
kind of a question too, so I
Okay,
can be on the border
Go
there.
for it. Go for it.
Always on the edge.
I'm on the edge. That's right. So, I'm agreeing with what both of y'all said, right? I can say that 7 years ago, we didn't have housing for the teachers. We didn't have enough housing for the firefighters and even police officers. We didn't. There was nothing. And so that's where my question comes in with Scott, because you haven't been here that length of time.
7 years?
It's been 7 years now? Wow.
Yeah.
Okay, cool. Have you seen that change? It seems to me that we do now have that portion, whether it's taken care of or whatever. Has that, as a changing condition, changed?
What I see and what these numbers tell me in this short window of time, particularly with the amount of inventory we've injected on the rental side of the equation, is for the first time in my 8 years of living here, 7 years at EPHA, we have had conversations with many folks that there are now options. They can choose something that better fits from an affordability, but kind of the affordability is the most important. But then what fits their desires, needs as a household? Never in my time here has that option been available to folks, where people have some choice in the market. As we reach stabilization on the rental market, that choice is going to become a little more limited again, but it is there now. We certainly have had a material impact on availability and the affordability of housing, but our work is not done. but there has been a positive impact in the last 18 months.
Okay, any other clarifications? All right, let's open it for discussion then.
Well, these are pretty good definitions, and I know I now, in my time here, I think I've had you review similar information to help us understand affordable, attainable workforce, and it begins to sink in. So I do appreciate it. It helps give us context. I'm not sure what the next state of conversation is from that.
So I want to raise a critique that I've heard frequently, that the density bonuses are just a giveaway to the developers and it makes their profit better.
Makes their what?
They get better profit because of the density bonuses. Now, the reasons I don't believe that is true, I mean, still any developer has to set prices in the market in which they're in. So, and it's a competitive market. Every real estate market is competitive. So I don't really think that's true, but the reason I think they say that is that the workforce has no limitation on income levels in our development code. And I am wondering whether we should consider putting a 150% of AMI limit on workforce to address that issue. I do think most of the developments that have happened tend to be targeted towards less than 150% of AMI anyway. But that is one of the major criticisms I keep hearing from people, that, oh, it's just a giveaway to developers.
May I offer a data point which is reflected in these slides? I think it is important to view this through the lens of how it's being used.
Right.
The workforce qualifications, the average household that we are moving in and qualifying are less than 100% AMI. The workforce definition is not being used to move in extremely high AMIs because those don't exist in quantity in this valley.
Well, and this came up particularly on this proposed development on along Highway 7, where the developer indicated that the expected purchase price would be $700,000 or more. And I think that led to that narrative on it, that look, 700,000, that's not workforce. Now, it can be workforce, of course. You can have people that earn that much that are in the workforce. But I just wonder, and it's a little different between private development and public development, like what the Housing Authority does too. The Housing Authority is focused and pretty much does limit based on AMI levels, but it's not required for a developer to do that under the development code, and I'm thinking that we should at least consider further limiting workforce to some AMI limit as well. The problem is any developer shies away from that too, because then they have to verify it, and there may be an ongoing verification requirement. So there are practical issues on how that might affect developers entering into the market that have to be weighed on that too. But I just raise it because that's kind of the recurring thing, and they're saying, well, these rents at Prospector, they're not affordable. And all we've done is allow, pad the bank accounts of the developers. And I just think that we may need to more proactively address that critique.
I agree. If at the time when we offered the density bonus, it was because we didn't have anything. There was nothing on the market.
Nothing.
And exactly what we talked about. Things have changed. I was not a big proponent of the density market at the time, density, but it made sense because we didn't have anything on the market. We do now. So maybe it is time for that change.
Maybe.
And if you're going to do a density bonus, then there has to be some kind of criteria with income. I can tell you just personally myself, when we talked about attainable workforce, I've told this before, I stupidly considered that affordable workforce. All right, but that's subjective, right? I mean, you have to define that what that AMI is, because an affordable for to keep on going back to high school, but affordable for teacher, now a fireman, because at the time they were all volunteers except for one, is it different than affordable for a barista or whatever. So that definition is very important. But I do think to go back and look at the densities and say, okay, if they're going to offer the density to a private person, then we have to have some kind of AMI attached to that. Now, how the semantics of that work, I don't know. But, I definitely think it's important, because if we just keep offering the density bonus, we're going to keep on having.
Well, and it comes up because there's very few developments that, as far as I know, there's probably more, but Prospector is the one that comes to mind where they use attainable. And developers basically stay away from attainable in favor of workforce.
And I'm going to be really raw about this. I'm sorry.
No, go ahead.
Be really raw about this comment, and I'm sure we'll get backlash. But I know when we first started talking about this density bonus, the community didn't want a density bonus of low income people next to them. They just didn't. Now, right, wrong, indifferent, what that low income is, I can't tell you. But they didn't want the picture of Section 8 housing in downtown Denver sitting next to their house. Totally, just truth, right? So for us to say, okay, it's workforce in this town, people don't understand AMI, they don't get it, which we have to explain it to them better. But I think that's an important fact, is that at the time we made that density bonus, people didn't want Section 8 housing next to them. Because that's all they could think of was the Jeffersons, or whatever. I mean, it's, you have to date yourself there. I mean, that's all I could think of was downtown Section 8 housing. And it's not what we have here, but that was the thought process. So, okay, sorry.
No. I think understanding that what we're talking about, may change as time goes on and housing stock changes and that kind of thing. But I'm curious about, when we talk about the missing middle, is there a defined AMI associated with the missing middle in terms of?
Typically, that's considered 80% to 120% AMI in the market.
Yes.
So that, if we're talking 150 and under, I think, my thought process on this is what is, as we accomplish, or, hopefully, it's always a moving target, right? We're not just going to be able to check it off the list and never touch it again. But as we accomplish different segments of AMI and industry in our community, and as that, the target for where our goals move, wanting to make sure that we're not, we don't feel that the balance is maintained, I guess. So that's really, 150 seems like that might be a reasonable piece, with a reasonable boundary that doesn't get us too tilted in one direction or the other. But do you see where I'm going, is wanting to have a healthy community, right, is a balance of all of those different kinds of housing options for our workforce, for attainable, for affordable, for our retirement community, for, all of those different pieces. And so thinking about how are we setting ourselves up for what's being addressed currently, knowing we have 50% on some of these newer projects, and where that, do you get what I'm saying? I'm not trying to lean into the question too hard, but I'm thinking ahead of 10, 15 years, where are we going to position ourselves? Are we now going to have a gap in a different segment of the community because we've focused too much? But is the 150 umbrella wide enough? Do you know what I'm saying?
It's a good question. I think 150% AMI as it's used, and remember, it is used in a rental context and a ownership context for anything that is restricted. It is serving us well, in my opinion. The data seems to point to that. I will say that when the town board made a change, because there was a slight inconsistency in the code, we still had one definition that was 150, one that was 175. We dropped it from 175 AMI to 150. Right. That gave me a little bit of heartache, because if you look out in the not too distant future, on the ownership side, there is going to be enough upward price pressure, in my opinion, that 175 will become closer to the target, or less than 175 on the ownership side when you pair that against construction costs, all the other criteria. And the data bears that out. So 150% AMI is serving us well across that spectrum now, but there could be a time where we need some slight movement in that up to the 175. More expensive mountain resort communities have had to push that to 200 to accommodate specifically that ownership component.
But
piece.
barring changes in our world, our economy, our town, the mountains, we never get to zero. You know, we're never going to have a place for everyone up here. We don't have the room. If 30 to 40% of the folks who are working in this town are commuting 30 years from now, an awful lot of them are still going to be commuting.
Yes.
There's just nowhere to put any size of houses to cover all the bases on that. And you've heard me talk about the future of transportation will evolve to, and that's out of my sideline because I'll be dead. You know, maybe you'll be around, Scott. But the point is, we can't get to zero, so we have to try to make progress on this in the areas we can. But some of those low incomes, I don't know where you're ever going to put enough places to get all of those people to be able to live up here and not starve to death.
Yeah, one additional point that is related to your comments there, Mayor. I would agree with you. When you look at the housing needs assessment, that headline number is not an attainable number in my opinion, certainly not by 2030. It is about developing a housing stock that provides options across the spectrum
Yeah.
and restricts enough of the percent of the available housing stock that expands and keeps those options available and their use ultimately restricted, so that we can try to have that balance over time.
Yeah.
One additional point I wanted to make that's important, given the amount of inventory and where that inventory has been focused in the past handful of months, 10 months that we've brought to market, we have essentially filled a bucket based on our needs assessment by 2030 in that middle income space. The focus now turns to home ownership across a wide spectrum of AMIs and that lower AMI need that is so significant we will never be able to meet the full need, but that becomes the shift now focuses in that area of 60% and below.
Yeah, I appreciate your
And
strategic
seasonal.
look.
And seasonal,
And
correct.
seasonal, and
Oh,
to
yeah.
that point, a developer is going to be very difficult for a developer to come in here and build something to be able to offer, because the housing costs that low income, low AMI, right? But my worry, and I've expressed that to you before, is that we're gonna saturate our housing here in the valley with the upper AMI and forget about our lower AMI. And if we're gonna be depending on a developer to do it, I don't see how they could build and be able to offer that. So I just want us to be very careful when we're looking at things, to not be just focusing on that upper AMI, even though there is need for that, but you have indicated that we're filling that nicely. But I think it's a challenge to be able to have enough housing with our limited space and building costs to provide housing for that lower AMI. And to me, that's where I would rather offer that density bonus to those type of developers that are looking at offering those lower AMI people a place to live and hopefully buy. So that's my concern.
So you're describing not eliminating the density bonus, but shifting it to that
For the lower.
Yeah, the lower.
I mean, I feel that we've accommodated what we were thinking we needed, but we certainly need that need for the lower AMI, and that is even more challenging to get things built because of cost. So I think that needs to be some type of incentive for that to be able to be built.
I agree with Cindy, and I think Bill's point we let this so wide open. Really, we're talking about, as you said, an incentive. And what are we trying to incentivize? And I don't think we're trying to incentivize high income people and expensive housing. We were trying, if we identify what we want to incentivize and then put that into our criteria. And it's not set in stone. Like Scott said,
Changes.
maybe in a few years we might have to change it to 175. And who knows? Who knows what happens with the economy and things? We'll have to put it down to 125. But at least look at it again. But really, defining what do we want to incentivize, and then set our regulations or our density bonuses to meet those, rather than not waste them, but you know what I mean, is using them on some things that really it's not our intention to incentivize, and that the community sometimes pushes back on, saying, why are you doing this? You're getting, because there are trade-offs with density bonuses of more density and the character of the community and what it looks like, and if it's just to have high-end luxury apartments, I don't think that's what the community wants us to do.
Well, and I'd really like to see something maybe be defined for home ownership. Maybe increase that, like you were saying, that gave you heartburn coming down to that 150 from that 175, and maybe we can bring that back. And for home ownership, we can include the 175. Go up to that, because I think it's important for community to have ownership. And not all kinds of condos with monthly rental. That changes too much. You want your community to be there and know your neighbors and have a diverse neighborhood, I think is very important too. So I would look at maybe incentivizing that ownership piece and allowing it to be a little bit higher.
You all said so gently what has been on my mind for a long time, that our focus perhaps is, I shouldn't say it in my own words because you said it well, and when you said we're in focus on the 60% now, thank you for doing that, because I thought we were going to be doing that initially, and I don't want that to get lost on people who it's hard, maybe it's difficult to get to a place of ownership or living here, but it's impossible for some people. And I think our focus should have been on the impossible, not giving a helping hand to people who might be able to, I don't know what that is. But I appreciate that focus is going to shift. I hope that is as fast as shifting a gear. I'm sure government does not work that quickly in your office either, but I think that shift is very important to the success of this and the continued community support, that we focus on people who have an impossible challenge.
And Trustee Earl, I'll clarify the idea of shifting. EPHA's focus has always remained on fulfilling the need for low and moderate income folks.
Okay.
We were presented with opportunities that allowed us to fill some of the stated need workforce and some of that workforce that fit the middle income, but our focus has always remained on the lower income spectrum through our LIHTC projects and others.
You might explain LIHTC, because I don't think everyone's going to understand what that is.
It's important to highlight that as you focus on providing housing opportunities for lower income households, the challenge that exists, that bifurcation or separation between the cost to construct and the rents that you have to be able to charge. This also equates to the ownership market. That gap is giant. And the only way you solve that gap, quite frankly, is through equity. More money on the front side. Paper napkin math would say if you were going to build 50 or 100 units, you would need roughly 70% or so of equity up front at that moment to construct and for that development to be able to support the debt that would be required for the remaining 30%. That's what it takes, roughly speaking, to provide rents at that 60% or lower. Nationally, the strongest tool available to us is still the LIHTC program. There's been some recent legislative changes that we have been fighting for decades at this point, that will be positive in the low income housing tax credit market, that I am hopeful will loosen up the competitive nature of those and increase funding availability for LIHTC, and will increase hopefully our ability to bring to market more low-income housing tax credit properties which focused on the lower AMI levels sooner than you otherwise could, because that is also a highly competitive market for those tax credits.
The simple response that I have heard, and one of my response is, housing is complicated, but I know who you can call. The simple reaction to that is, well, why are we putting money into fancy places to live when we just need a place to live? And so any effort or money that's put into something that is on a higher income, the perception is, why aren't we focusing? What are we paying to? Why are we paying this tax? Ask hotel owners and things, they do pay the tax. So at a very simple level, I hope that focus remains very visible to the community as well.
Sort of in that vein, I wonder if it would be helpful. We've only got a few more minutes on this topic, I know. Oh, we only have a few more minutes on this topic, I know. But Scott, can you talk about the 200% density bonus and how that number fits with low-income housing, both in the private market and in the housing authority market? Is 200, is that a number we should be thinking about one way or another?
Yes, in my opinion, it is. In my opinion, if we're discussing what are we trying to incentivize, pair that against our cost to build, cost to construct. 200% is a start. You see in the data that when it was only 150%, the market responded and provided no additional units. Finally, at 200%, it loosened up a little bit, and the market provided 188 units. That inventory still took 9 years to come online after the implementation of the 200% bonus. What may make sense from a policy perspective is some of the conversation that's occurred here today, providing potentially even greater density bonus, but with more strict criteria based on income. That could be an option. I'm not making a value judgment on whether it's good public policy or not, because there are a lot of things to weigh in something in that structure. But I think there will be select opportunities that fit with the character, the built environment character of our community, where additional density beyond the 16 units per acre that's currently allowed under that, where higher density could be built, would be necessary to provide the housing in the low income spectrum. And it can be done tastefully in select contexts. So I think incentivizing and having a tiered structure could be an option from a policy perspective. Does that answer what you
Yes.
So, just to see if I can recap, this question of what should be incentivized. I've heard a number of thoughts on this, that perhaps the incentivization to the missing middle has been effective and there needs to be a focus on the lower income. Perhaps we should be thinking about making the 175% AMI come back, especially for home ownership, because of how you want homeowners in the community. A lot of questions about can we incentivize through the tools we have, the filling that large gap for the 60% and under, and a number of other things. I guess the question I have at this point is, where do you want to go from here? Okay, because you have an existing code and you have a code update process happening. What is your thinking about where you want to take this
Maybe
topic?
the same thing as the prior topic, that there may be a study session or discussion item in the formal board session, and perhaps verbiage, as Travis suggested on the prior topic, perhaps verbiage of a suggested amendment that addresses the density bonus, making modifications to it, gets us started, gives us a target to shoot at, and we can modify that as we see fit.
Other thoughts on that? Not
I think
to-
the mayor hit it. I think I'm hearing a consensus. We need bumpers around that density bonus, and we don't have that now. It's kind of just out there.
I
And staff could maybe come back with some suggestions.
We've still got to figure out the impact on the market and whether that impacts the development of that. If it frustrates the development of it, I just see this as a longer term study as to how the market is likely to react to changes like that. I would be hesitant to move too quickly on that, and
Right.
it seems like it fits within the whole development code rewrite anyway.
Yeah.
I'm not sure this is so urgent that we need to do it right now.
Well, there is information that we need regarding that. Now,
Yeah.
how to define that, he defined it a little bit. I'm not sure, Steve, whether you have a sense of what would we need to know to put that type of amendment together. Bill, maybe you can itemize it.
Well, I think you have to have some discussion with developers. Basically, I just think, I don't know, are they willing to do any income restriction at all? They haven't shown that they have been with attainable housing, and so that's a bit of a concern, and sometimes there are unintended consequences of these things, and I just want to make sure that's not an unintended consequence.
It might not take long to do some interviews. There probably would be eagerness to provide input. I'm not sure who would be in front of it.
Yeah, I'd hesitate to use the lack of usage of the attainable provision of our code, because if you look at how the code is structured, there's no additional benefit to building attainable housing over workforce housing.
Right.
And workforce housing is more flexible. So it's not surprising to me that no developer has chosen to take the more restrictive path for the same benefit. So I just want to make sure that we're not using that as a marker of, well, the market is not willing to do attainable housing, because right now, I think the reason that they're not is because we have workforce housing, which is very much more unencumbered.
I think we need to be careful too, a little sensitive to us going off in direction on this one little part that's going to be in the development code when we've got a development code process going already. I don't want to undermine that or minimize that. And if there's not a real rush, maybe we can, as the board, encourage the folks working on the development code to include this in that. But we can't be taking little pieces out of the development code and us doing those off to the side while the process is going on.
Let's get some study and information.
So specifically, a couple of suggestions have been raised just now. One is to have some language that you could talk about, not necessarily actually choose to amend currently, but give you some language that helps you to clarify the discussion. Another idea is, rather than having an amendment at this time, have a contribution to the code update process around this that has a larger consideration. What would and I see some nods around that, what would your process be? What would you need to do to be able to significantly contribute from your experience, your past experience, to that development code update process? What could you do, or what would you need to do as a joint group here, or as a town trustees? Is there some step you would want to take that would help you to further this
I think the
conversation?
mayor had it, that we need to study and figure out what the questions we need to ask and of whom, to get a better feel for things like what Scott said about maybe you have a tiered structure of some sort. I'm just not sure we know enough yet to even go to a language.
Right. So that's that question about how is the market likely to react? Is that right?
Yep.
Yeah. And some other elements as well. How do you envision that happening?
How and who?
Yeah, and who? Because you're not automatically, the ferry is not going to bring you the data.
Well, this is what staff is for, in my opinion.
Which staff?
I think it's the housing authority and the town coordinating how do we analyze market impacts of what we're doing, really in the whole development code. It's because, you know, theory is one thing, practicality is a different thing. And I'm not sure we'll ever be able to predict with great accuracy, but, you know, I think the practicality side is an important part to consider.
Would it make sense? Oh, sorry, Travis.
No, we may be saying the same thing. Go ahead.
Would it make sense for us to use this conversation as some additional direction and context to the development code rewrite team as they develop this section of it? Inject this conversation and points that were made today into that. I think they can inject their expertise and broader reach to include some proposals in that process.
Oh, yes, but what's not at the table at this point, unless it is with the development code process, are the developers.
They're part of that process.
Yeah, you're
Yeah,
going to
they're
need
the process.
insight across the board.
This sounds to me like a good way forward with conversations and with a study session. I would suggest that the folks who are writing, and Steve knows better than I, but the folks who are writing the code for us are not going to have such a clear sense of our housing market that they'll be able to bring something stronger. And there's going to be enough conversation happening on other elements of the development code. This is going to need to be a separate conversation anyway, whether it gets adopted with the development code or beforehand. So it makes sense to me to move to a study session once information is gathered. Recognize though that whatever developers say today as feedback, the economy changes and it's going to be completely different. So we have to take it with that understanding.
And there are other factors that'll change between now and the adoption of the development code too, like a fairly significant couple of elections locally.
So can you strike the bring a draft amendment but staff is okay. So staff, no, stop. Just, it's not to bring a draft amendment, it's to, provide some
Concepts for consideration.
concepts for consideration and data, that may be gathered from the development code update people, is that right? Because they are having a focus group with developers and realtors and stuff like that, right? So, do you think that'll be adequate information for what you're asking
it'll
for?
help.
Okay, so staff,
It
Being-
may lead to iterative questions.
sure, so that staff being town and housing authority, correct?
And I think the study sessions being both planning commission and town board, so that both groups are seeing it.
Separately or together? Separately or together?
Given the challenges of getting this group together, we only unfortunately have two planning commissioners here today. I would suggest we do that separately on the regularly scheduled study sessions, just to make sure we get everybody's input as we go through. And then I was going to echo what Scott was saying. I think that injects back into the development code process with that additional work that the town has done that's probably out of scope for our development code update consultants.
Okay. We done with this topic for now? Yeah?
Sure.
Satisfied? Okay, great. So there's a question of, do you want to meet again as a joint group? Obviously, there are challenges to that. Before you said you wanted to meet quarterly, unless you changed that. There was a 4-month gap between the last meeting and this one. What is your thinking on that? And I'll just remind you that we had in our parking lot from the first study session a number of items you said you wanted to talk about, including annexation, the gap between the comprehensive plan and the current zoning criteria, definition of mixed use, examine current development code to see if it meets current housing needs. I think you're doing that now. ADUs, more incentives for builders to build smaller units. Those were all possible topics you put into the parking lot. You've raised some of them at this meeting. What do you want to do? Do you want to have another joint study session? If so, what do you want it to be about, and when do you want it to be?
Well, of those topics you mentioned, annexation is the one that is really going to take some momentum at some time. It's going to take us a while to build it. We had an initial study session on it a few months ago, I think, and I know there's action happening behind the scenes, I think, in regard to that. That one might benefit from a joint session at some point, though I'm not sure there's a it's the long-term urgency, if I can call it that. We do have to turn that corner eventually on having a true annexation policy rather than this ad hoc world that we live in. I think. Do we set another or aim for another meeting to talk that? Most of those other topics, I wouldn't say we'd need to put a session together, but correct me if I'm wrong.
What do you all feel about that?
I agree. I think that's the type of thing that would benefit from a joint session.
Yeah. Such a broad field.
I'd suggest we kind of have two separate meeting styles here. We have the regular check-in meetings, which have come up a number of times, more of just a gathering point, not a specific set agenda necessarily, but a chance to get together, talk about challenges or things that you're seeing. That being more regularly scheduled, maybe twice a year, once at the beginning of the year to wrap up the prior year and talk about the coming year, and maybe once as a midpoint check, and then ad hoc meetings as necessary. This meeting and the previous meeting were those ad hoc, very special topic meetings, and I think if either body wants to call a joint meeting together, we can make that happen for those specific items. And it does sound like annexation may be one for later this fall. But other than that, having maybe just those two standing meetings a year, I think it would be challenging to fill a quarterly standing meeting. And I think it'd be very challenging to coordinate it, just being blunt.
Sounds good.
But I do want to, I would encourage us to have the standing meetings. I think that communication between the two boards is helpful for both bodies.
Does the board generally, like a January, end of the year, next year, check-in, and then an August kind of midpoint check-in make sense as those standing meetings, and then ad hoc as necessary?
Yes.
Sure.
Because it's much easier if we can get it on the town clerk's schedule early, because then they can get everybody on the same page.
Do the commissioner terms usually expire at the end of March, right? Is that something?
Yeah,
think
March
so.
31st, and
Think so.
you got 2 in 2028 and 2 in 2030 or
And
something.
we have board meetings too, so it might make more sense to target that end of April for so April and October for
Yeah.
those standing meetings, so you catch new board members and new planning commissioners.
Yeah. October ends up being all interesting with budget.
I'm not sure
but-
April would be great for new board members because they would have been like really new.
Well, you're
Just
talking about
sworn in.
recapping, and recapping should be the old board members,
Right.
not the new
Yeah.
board members.
Because they won't
and
come on till.
We can
First of May,
schedule it,
right?
and then we'll see if it
Yeah.
works
And
well or poorly.
Yeah,
And we can
January,
move those
February,
regularly
August, that's a
scheduled
6-month
meetings.
interval.
Yeah,
Yeah,
I just think brand new board members don't. I mean, you're just kind of lost, and
yeah.
We do for new board members, and we should for new planning commissioners, do kind of an onboarding session specific to Steve's team does one, so you know what's going on, what's coming up, what the major items of discussion are.
you're talking to somebody who's been in it all his life. Talking about new board members have no idea what's going
Yeah.
on. It is such an overwhelming, like,
It is.
you know, to be productive. I think if you were doing a recap, you should have the members that have been
Yeah.
on for a while. You know,
I
and
agree.
then
So what dates am I hearing then? What times of the year?
There are two separate ones, January and August, or April and October. What are you gonna land on?
I like the January and August.
I do too.
I think so.
Seems to be some consensus around that.
Or
Good.
February.
Okay, so,
After that.
I suppose, so do you want to try to schedule talking about annexation sometime soon as an ad hoc meeting? Or is it too early to have that discussion?
I have a sense that we should keep that topic moving forward. I think it's almost a multi-year process to get to a point of that. So I do think before the end of the year would be a good thing to gather
Point,
this.
then a point of clarification, Steve, does the planning commission have any involvement at all with any annexation discussions? So maybe we can make it a little bit easier for you guys to schedule if it's just a town trustee conversation.
Well, you know, when you annex, you also then have to zone. And I think you'll have a role in zoning, right?
Okay, right.
So, okay, so it sounds like you do want to have a joint study session on annexation?
Maybe a November, December kind of thing, away from the heat of all the action here.
Staff can follow up, and we'll follow up with the town board and the planning commission.
We don't need to try to set anything here.
Okay, and do you feel it's useful to have it facilitated, or you want to just facilitate it yourselves?
I thought you did an exemplary job today on facilitation, and we accomplished our assignments.
Yay!
So I kind of like it.
It's the heat.
We're on time, but she's in a minute.
So I guess a big question in my mind is, who's the holder of current information? Who could liaise with us about annexation that would help us design an effective meeting for you all? How do we do that?
Well, Steve's the point person.
Look, Frank,
Yeah.
Frank and
No,
Grant.
it's really directed
Steve,
for us.
Frank.
Yeah, it's probably more of a staff. I mean, I'm glad to help.
Yeah,
I think
it is more of a
it's more of a staff issue, Stephen.
And it's already in the works to some degree, though
Yeah.
it's not top.
Well, maybe if you all would be in agreement, we could at some point meet
Staff
to,
emeritus.
once we know more or
Staff
less when the meeting's gonna be, we could at some point meet to,
I just want to honor the governor's say of what the
Yeah,
body of
right.
board is versus staff.
Yeah.
Okay,
all right,
I think we've got it.
yeah.
This meeting is adjourned.
Thanks, everybody. Good job.
Thank you.
I know.